So you walk into family court thinking the judge holds all the power. He's wearing the robe. He's got the gavel. He's got a face that says, I'd rather be anywhere else but here. But actually, the real power, it's that Cafcass officer, the one in the cardigan holding the clipboard, who just said, we're recommending a guardian be appointed under Rule 16.4. And suddenly, the courtroom shifts. You're no longer just fighting your ex. You're now fighting a state-sponsored professional with party status and their own solicitor. Congratulations, you've just leveled up to boss fight mode. So, what is a guardian, and why they look like a librarian but hold a legal chainsaw? A guardian, specifically a Rule 16 guardian, is someone that the court assigns to speak on behalf of the child. Because apparently, when mum's screaming about emotional abuse and the dad's muttering about alienation, no one's qualified to speak for the one person actually being affected, and that is the child. So now, here's the kicker. This isn't just someone checking in with the child. They become a full legal party to proceedings. That means they can instruct a solicitor, yes, that's right, your toddler now has legal representation, file their own statements, cross-examine you in court, and submit a recommendation that the judge will probably treat like it come down from Mount Sinai and one of on the stone tablets. They're meant to be independent, neutral, and child-focused. They're meant to be. Depending on who you get, you might end up with a child-focused investigator or a part-time psychic social worker who decides your fate based on a single phone call with yourself and 2 phone calls with your ex and a vibe. So why are guardians appointed? Spoiler, because the bloody adults can't be trusted. Ultimately, you don't get a guardian just because your ex blocked you on WhatsApp or because you brought the wrong brand of fish fingers. No, guardians are appointed when the court is basically says, well, these two are at war. The kid now is at collateral damage. This is serious shit. We need someone neutral to figure out if anyone in this fucking room has got a clue. The reasons for this include serious safeguarding concerns, real or fabricated. One parent saying you're dangerous, you're saying the other parent's emotionally manipulating. The child is collateral damage. The judge is thinking, time to bring in the big guns. The child's wishes and feelings don't make sense. Like when your 8-year-old suddenly turns around and says they're feeling emotionally unsafe. A phrase they've clearly learned from someone who's read one women's aid leaflet and thinks you asking for handover times is domestic abuse. Now, social services, they'll be sniffing around, but they haven't hit the panic button yet. The court wants an independent assessment. Now, they want this assessment before the child ends up in foster care, or worse, with Nan, or worse still than that, with the parents who owns all the Buzz Lightyear merch and none of the emotional maturity. High conflict contact breakdown, basically, otherwise known as we've reached the point in this relationship where the child needs a lawyer. A guardian gets called in when the court says the grown-ups are failing. Let's see if the system can do any better. Again, spoiler alert, sometimes it does, but sometimes it doesn't. Depends how you react. Now, there are many different types of guardians because one isn't confusing enough already, is it really? Now, let's do a roll call. Now, number 1, the 16.4 guardians, private law. Your bread and butter guardian, appointed when the court wants to know if little Johnny's refusal to see dad is free will or weaponized trauma in a school uniform. Public law guardians, care proceedings, these ones step in when the local authority is going full Hunger Games and trying to remove the child from the home. They oversee whether the social services are on the right track or just bored and overzealous. That happens. And you got the number 3, NIAS guardians. NIAS is like the indie band of the guardian world. Cooler, sometimes better, chosen when Cafcass has a conflict of interest, a guardian who's already messed it up, or a court that says, can we get someone who has a fucking clue? Number 4, guardian and a guardian ad litem. Now, civil adoption legacy cases, mostly extinct. Think legal dinosaurs only appear adoption cases, and weird civil disputes involving kids and car crashes. Weird. And obviously you've got the standard Cafcass officer, the Cafcass Section 7 report writers. These are not guardians. These are people often confuse the two. These are the ones who will call you once, talk to your ex twice or 3 times, write a 6-page report, and then decide You're either Jesus or the Joker, and yet they hold more influence than your own bloody parenting history. Crazy. Now, how can you spot a biased guardian before they gaslight you out of your own child's life? Now, you're in the courtroom. The guardian starts speaking, and suddenly your stomach drops because everything coming out of their mouth sounds suspiciously like your ex's WhatsApp rants, but with a professional accent. And here's the checklist of doom. They echo one parent's narrative, word for word. Mother's reports that father is emotionally controlling and struggles with boundaries. Really? Really? Was this determined but through an actual evidence, or did you just copy and paste her witness statement and swap a few of the emojis for more sensible words? Next one, they treat the child's wishes as infallible. The child says they don't want to see dad, and you didn't ask why. Did the child also say they were a velociraptor who eats clouds for breakfast? Because that deserves some level of scrutiny, no? But they punish you for being involved. So you email the school, you ask for updates, you turn up to parents' evening. Now you're controlling. Apparently, being a consistent caring father, is a red flag for Cafcass now. They've also got they ignore external sources, so no school input, no GP contact, no therapist consulted. Just a 45-minute house visit and a report built entirely from assumptions, dated risk models, and their gut feeling. Once you see 3 of these red flags, you've got a guardian that's either dangerously lazy or quietly biased. Either way, it's time to go forensic on them. Now, do they have any real qualifications, or just a magic clipboard? You'd think, wouldn't you? You'd think that someone with the amount of power and influence that they have, the control they have, is whether or not you get to see your child. I mean, I don't know, they'd have some sort of expertise in childhood trauma, surely. Attachment theory, coercive control and behavior, the alienation, you'd expect so, wouldn't you? But nothing. No, nothing. Not a thing. They're usually a registered social worker with 5 years post-qualification experience, a few days of Cafcass onboarding, and access to an internal training video from 2006. They are not psychologists. Trauma-informed clinicians. They're not courtroom savvy almost. They're forensic analysts. So when you bring up things like protective programming, pathological alignment, or trauma bonds, they stare at you like you're quoting something from the Matrix. And yet they get to have a walk in court and tell the judge that you're emotionally risky. I mean, what the earth? They make recommendations based on 2 hours a week at contact center. So yes, they have credentials, just not the ones that your child actually needs. Now, what to do if the guardian misses emotional abuse, otherwise known as the moment you go from dad to being detective? Right, you stayed calm, you played fair, and the guardian walks in and completely ignores the fact your child is clearly anxious and repeating adult phrases such as showing classic symptoms of enmeshment and fear-based rejection. And the guardian's conclusion, it's just conflict. Let's reduce contact with dad and let's hope things settle down. Congratulations, you're being professionally gaslit. Here's how to handle. Step 1, switch to safeguarding language. So basically, say stuff like, I have concerns about emotional scripting and coercive alignment. My child is using language that suggests external influence, not independent expression. Do not say, she's brainwashing my kid and the Cafcass are blind to see it. You bloody idiots. You sound smarter. The court listens more, and the guardian can't dismiss it without looking negligent. Step 2, introduce evidence with pattern-based context. Now, don't say, for example, she's blocked all my fucking calls, I can't fucking get hold of her, she's fucking top. Don't say that. Now, what you do say is, between date and date, there were 14 missed calls, 3 ignored text messages, and 0 responses to school-related contact. This pattern aligns with intentional obstruction and forced psychological distancing. Step 3, ask the court to test the recommendation, submit a statement and asking for a psychological assessment, fact-finding hearing under Practice Direction 12J, or additional directions compelling the guardian to obtain third-party evidence such as a school, EP records, or therapist notes. Quote case law if needed. REC Parental Alienation 2023 or EHN 2021 Children Act 1989 Section 1 Paramountcy Principle. Step 4. If needed, complain. You use Cafcass's own policy against them. The guardian failed to investigate safeguarding concerns proportionately contrary to internal guidance and statutory duties. Attach the dates of communication, and ignored evidence that you put to her and that they've ignored it. Put that all into the pack as well. Let it show the bias and laziness. Just don't just raise about evidence it. Document it. Dissect it and destroy it. Look, don't fight like a dad. Fight like a surgeon with receipts. So, what is a guardian? A neutral voice, a biased echo, or a well-meaning social worker dropped into a legal war zone with a clipboard and a prayer? And you know what the real answer is? It all depends. It depends. What matters is how you respond to everything. Don't get emotional. Get strategic. Don't shout. Bias. Get forensic. Don't act like a victim. Act like an only grown up in the room. Because the guardian isn't always the villain. But if they are acting like one, then become the hero with evidence, elegance, and absolute emotional control.